Okay, to the Arizona state legislature that wants to act like, oh, well, the law's on the books, but we're not going to enforce it. Stop lying to your constituents. It is not that, oh, it's gonna stay there on the books, but we're not going to act on it. No, you need to have cause to be able to act on it. You need to have cause to be able to bring it up, to actually be able to enforce it. Alright? And we're talking constitutionally enforce it. Alright? A law that has been on the books since 1864 that carves the pathway for abortion ultimately would not be able to be enforceable in the year 2024. Ultimately, because first off, it would need to be argued exactly how long you had to go ahead and be able to present the reasons that this would need to be debated as long as it had been debated. Well, meantime, I believe it's Herring versus New York State ended up going ahead and taking from February 1975 until June of 1975. In 2024, cell phones and electronics have existed now for decades. Alright? So ultimately, decades to have to debate over a decision that ultimately would have been able to be more expediently debated upon. You know, if everyone involved with the debate was actually good faith actors. Ultimately, that's like going ahead and trying to establish a statute of limitation on why somebody ended up winning the lottery, but because of the factor that it wasn't timely, you know, it wasn't in a timely manner being able to explain why you deserve to go ahead and attempt to shake down somebody for whatever financial compensation that you feel entitled to. Alright? Ultimately, when somebody says, fuck you, bring me to court, understand they have an argument. So for anybody that wants to go ahead and try to go for, to become a constitutional lawyer, actually go for the bar exam in whatever form you go for it. Alright? The answer to this situation was, with that setting the precedence of statute of limitations, it ends up showing the factor that the decision on that would have been able to be argued within a matter of a 3-month span. And that at any 3-month point, it would have been possible to go ahead and be able to openly admit without reputational harm the reason of believing that publicly and societally that it should be accepted, that you acted as soon as you could to get resolution to that debate. Alright? But as far as enforcement, ultimately, the 1964 Civil Rights Act, that ended up going ahead and establishing the factor of voting rights, within minority communities, and within minority populations, ends up going ahead and establishing the factor that the basis of the term systemic racism is just that. The racism is injected within the system. Alright? Ultimately, just because of the factor that somebody does not want to believe that racism exists, does not therefore negate the factor that racism does exist. Alright? That in itself, racism is a form of discrimination. Alright? Now, when it comes to rights and discrimination, ultimately, there are other populations that get othered. Like, for example, the disabled community. Hi, disabled. How are you doing? Ultimately, the Americans with Disabilities Act ends up going ahead and giving assurances that when we are discriminated against with subpar treatment, subpar service, just it does not meet the same standard that anyone and everyone within the general population would end up going ahead and be considered the standard. Alright? Notice the standard, meaning one standard. This standard has to be met across the board, not excluding anybody. Anybody that gets excluded, that would literally end up being the grounds of the base to prove the discrimination. Alright? So ultimately, if you were to look at the application of the law in the first place, and you were to take a stance on the way history will be looking at it as far as the development of law and technology and the application of where they intertwine. History, if had personal autonomy, would be saying, you can't own people. People are people. People have their own rights. People have their own bodily autonomy. People have their own... They have the decision-making capability. They have the potential and possibility of being able to become whatever or whoever they would like. Alright? Does not mean that they have the guarantee of becoming whatever or whoever they would like. It just means that anybody has the possibility, anybody has the potential. It's just about actually going ahead and doing the work to be able to meet that potential. Just like, for example, if trying to argue for a fetus, which if you were to claim, autonomy of said fetus and personhood, ultimately, if you were to compare it to anybody within the disabled community, it would be the equivalent of attempting to advocate for somebody with full-blown mutism. Alright? Ultimately, they may not be able to vocalize or, if not taught how to be able to use alternative means of communication, it means that communication may be difficult, but would not be impossible. Alright? Because that would also mean, impossible would mean non-existent, So, that being said, alright? If a person has the capability to speak up for themselves or argue up for themselves, they have ability to be able to argue their point and their perspective. Ultimately, if the actions that ended up being taken to go ahead and change the platform or venue of which you have to go ahead and be able to speak up for yourself, ends up going and being changed by circumstances of groupthink. Ultimately, what ends up being the differentiating factor between a debate and having to argue a defense in a deposition in a court of law. Alright? While at the same time, in order to enforce a warrant, it needs to go ahead and be enforceable and based on legal application. Alright? So, trying to go ahead and turn somebody's personal opinion into the legal, no, this is just how it is, because I can, because I said so. Ultimately, if it had capacity and capability of being able to go ahead and act on said warrant without having to worry about the potential acquittal, recusal, or, potential lack of capability of removal of emotional responsiveness based on the attempted repainting of narratives in an attempt to go ahead and try to use words to try to split hairs to why you feel that you should be legally in the right to be able to enforce what you believe should be a enforceable legal request. If the person denies it and says, hey, go to the court and you prove the legality of having to listen to the request of said warrant, based on Constitution, which obviously, with that being the foundation and the guardrails, that the threshold of, burden of proof has established, then because you feel that because of my attitude, that I would be more aligned with attitudes of people that you view would be better being segregated from society. All right, so you're trying to go ahead and argue that segregation is constitutional? All right. Well, I mean, the Supreme Court already has established the fact that solitary confinement has been deemed psychological torture and that it's considered unconscionable and ultimately, regardless of the circumstances, cannot be utilized, on an elongated period of time. All right? If you could only enforce something periodically in order to split hairs and be right on a technicality, then ultimately the conscionable active application of utilizing said means does not mean that it is justifiable. All right? So if you're trying to get a warrant triggered on somebody because their belief is different than yours, and you believe that you're right and are willing to do what you can to muddy the process in an attempt to be perceived as right, that means that you've already established within yourself that you're wrong. So, like being said, those warrants based on, the attempted application of abortion, which, by the way, was supposed to be a hypothetical, constitutional law exercise implemented with the framework of the game Dungeons and Dragons to be able to go ahead and measure and mitigate with the application of law and protocol and the execution of law and the constitutionality of the legal, request ends up going ahead and being, and ultimately how conscionable and what thresholds would end up being met, should it be actually submitted within the legal, within the judicial, system to be debated on, in a civil litigatory process. All right? So, Arizona law could not be enforced upon as far as any warrants, as far as any murder investigations or anything like that, because of trying to claim, fetal rights, because of the fact that ultimately the Americans with Disabilities Act would end up going ahead for somebody that's disabled and trying to claim you have a right to shut them up because you feel that with them being disabled that they're flawed because they don't meet your expectation of what you thought you were going to get or what you thought you were signing up for. Because ultimately, you were given possibilities. You got the possibility of being a parent. Doesn't mean that the child's going to end up going ahead and making it to life. Doesn't mean that it's going to guarantee to be making it to conception. All right? There was no guarantee that that was going to be the inevitable final outcome. All right? It was only a potential possibility. A potential possibility that there are resources and means to be able to prevent that potential outcome. All right? And try to mitigate the risk. All right? So ultimately, you have to go ahead and give a guarantee on the situation. Like, you have to give a guarantee. Like, no, I guarantee that if I go and I say, no, I am acting on this warrant to go ahead and arrest you. It is constant. I am within my right legally to be able to do so, and the Department of Justice trying to stop me from doing so would not go ahead and have any ramifications on the society, the rules that society has dictated are rules. Like, for example, the right to, first off, a speedy trial, which that would have been in a 3-month span. So going and debating for months on end ends up going ahead and closing the window that would have been had to claim investigatory, propriety, on the matter. All right? Not to mention that. But ultimately, the statute of limitations, there not being one for discriminatory basis because of the unconstitutionality of the circumstances, yeah, that does have a victim. The persons whose rights were oppressed. All right? And obviously, for the person that ends up going ahead and doing the oppressing, they're going to go ahead and try to debate, I had a right to act in the way that I did. So you had a right to dehumanize somebody. All right, you had the right. You had the possibility. But, or you claim you had the right. You personally were in the personal belief that you had the right. But what legal right do you actually have? All right? Ultimately, if your decision could cause ramifications for everybody else who believed that it was also a good idea, and then try to shrug it off as a joke, if your joke could potentially cause you to end up confined in a facility that would segregate you from well-adjusted, or what would be perceived as well-adjusted members of society, and cause you to be segregated to where potential threats to your safety would always arise, and you personally feel like that would be somewhere that would be more fitting for the person that you believe that you had the right to oppress in the first place, while wanting to argue why you had the right to oppress them, understand, I don't know a single person that would aspire to be a lawyer that would want to be the person within that career that would have to argue that to a 12-person, panel, a jury, as well as a judge. All right? That's why rules for thee, not for me, does not fucking work or apply as far as legal and judicial precedents.